Glad you could join us. The kids are back in school in Broward and Miami-Dade counties, and for the first time, every school has a police officer or a guardian on duty.
That is now state law, a mandate that is part of tightened security at Florida schools in response to the mass shooting at Marjory Stoneman Douglas High School. A charter school in Davie opened this week without an officer nor guardian on duty, though administrators there cited difficulties finding someone qualified. Concerned MSD public safety commissioners demanded Broward school superintendent close that school as unsafe. They also laid into him for what they consider a long overdue investigation into the actions of 5 Douglas High administrators. Robert Runcie is with us to talk all about that and more. He is Broward school superintendent since 2011, overseeing the district's 271,000 plus students in 337 schools and 30,000 plus employees. So great, Mr. Runcie, to have you with us, Superintendent, this morning. Thanks for coming in.
Thank you for having me.
We are so glad you're here. When school started in Broward, there were reports that more than 24 schools, charter schools, did not have the state mandated security officer or police officer on duty. Now it turned out to be actually one school. Is that right? A championship academy in Davie.
So it is right that there was only one school. It isn't correct that there were 29 schools or so that were not compliant. What occurred with that list of 29 was something that was asked for us at 8 p.m. the night before the commission met, and they asked for us to identify schools who we believed at that moment in time did not have some long-term plan. That's very different than being in compliance today and tomorrow. And so what we've done, which is probably a little different than most districts because we certainly understand the scrutiny we're under. I've asked staff to not only look at information that the charters give us certifying their compliance, but also to audit and check. And on the first day of school, we had staff actually go out into the field to determine and ensure
that they were staffed.
And we found one where that was not the case. Now, things do happen, but in this case, they knowingly opened that school, recognizing that they would not have any protection for the first 2 days of school. In fact, when we looked at the schedule, we identified up to 16 days in which that was not the case. So
but they paid a price.
They paid a price, and we are very clear. We will accept no compromises to ensuring the safety of students in Broward County, and we are ensuring that everyone is in compliance with state law. It's the right thing to do, and so I think this is this decision was done though, and again, to credit to our school board, who always puts the children first. The decision we made was not only to revoke the license for the charter, but we did something that we haven't done before, which is we kept the entire family of students and teachers together so those relationships could continue and minimize the impact on the students.
All right, Superintendent, I want to jump right in here, which this is something that I think is the public perception. What you just said was this school, you took action on this school because they were not in compliance. You held them accountable, but it was 2 days that they were open before any accountability. So what the 2 days, what was going on in that 2 days where the district did not hold them accountable on the first day of school without a guardian?
That's not correct. We went there the first day, we noticed them, and we immediately put an item on the board agenda to terminate the charter.
So it was the process you had to go through?
It was a process. In fact, that was in play the first day of when school opened. So we took action immediately when this occurred. In fact, we went over and we had staff there at the charter and helping to navigate things so that they could actually get someone on campus. So they had an officer by the end of the day on the second day. But again, we had concerns that the law was violated. Yes.
And you knew that this school was having issues since March, and the letters and emails go back to March. You were on it. You were seeing what they were doing, the difficulties that they were having, and in fact, all schools had more than a year. This is a law in the books from March 2018, right? So, what is your issue as a superintendent with these schools that had so much time coming down to the wire this week in their contracts, be them short or long term?
Well, I think they need to understand that This is something that needs to be taken very seriously. Yes, you had over a year. Back in 2018, I had staff sitting in front of charter school operators and administrators and saying you need to follow the state law, what's required, that we have a safe school officer on every campus. There were some that felt that the law didn't apply to them, so that was clarified in Senate Bill 7030 this past May. And once that was passed, the Commissioner of Education sent correspondence out to the charters and districts saying you have to comply. We had numerous meetings with charters. We laid out various options for them to comply with state law. Do a contract with municipality for a school resource officer. You can schedule someone for a guardian program. You can go ahead and contract with a third-party service that has individuals who are certified. There are numerous options that were out there, and we continue to work with charters to help them to take advantage of those.
All right, at this school in Davie,
yes,
532 students, I don't know how many faculty. Essentially, the school board has what? The district has taken over the school? I mean, the kids are still in that
The kids
facility?
are still there, the teachers are there. We're managing the school, we're making sure that they're in compliance with state law. In fact, one of the things we've done, areas where we've seen there's been what we feel a gap in resources, we've added things like counselors, social workers, other staff personnel positions that we would have in any of our schools. So we're going to treat that school and provide them the resources as we would any other school in Broward County.
Are you letting other charter schools get by without counselors, without the resources?
Well, let me just say this. That school is under our management now. There's two types of schools in Broward County. There's district managed schools, there's charter managed schools. Charter managed schools are independent of the district. They have their own governing board. They have their own set of policies, rules. We have limited ability to govern a charter. We can help enforce state law and hold them accountable and revoke the charter. Outside of that, we can't manage the charter.
Superintendent, this week the commission, Marjory Stoneman Douglas Public Safety Commission, was very critical about the investigation of your district into the 5 administrators, 5 employees at Marjory Stoneman Douglas, the principal, 2 assistant principals, a school safety specialist. I think I may have his term wrong, but your investigation into their actions or inactions that led up to that massacre on February 14th of last year. What is taking so long? Are they right in their criticism?
You've hired a law firm.
That's correct.
Last November, and they were supposed to have a report by April. Why
no,
haven't they done that?
we hired the firm. It was a little bit later than that. But let me just say this, that one of the things that was missed around this, folks say, well, you know, why didn't you start in 2018? The chair of the commission reminded everyone that it was the commission that asked us to stop our work and wait till they completed theirs, and we would be able to use that information. We hired a firm. They are doing a thorough job. They're going through every single piece of documentation that's required. They're working with the investigators from the MSD Commission. They've completed a couple of the investigations so far. Those individuals have been noticed with the report. They're going through our due process within the district. And the last update I received from the firm was that they believe they should be done within 90 days with the remainder of the investigations.
Right.
That's taken us to about October.
You
So
Mr.
yes,
Wright,
I agree that it's not being done as fast as it should be, but we have to make sure it's done right. I put lots of pressure on them and try to make sure we could expedite it, but I can't change the work being done properly, and I wish we could have had it done faster, but I can assure everyone it's being done as fast as possible and it's being done correctly, and that's what we want.
Superintendent, when we come back, we're going to talk about, change the focus a little bit, what may be an unprecedented pattern of threats against South Florida schools.
That is the... Welcome back. Our guest this morning is Broward Superintendent of the Schools, Robert Runcie, and we are focusing, among other things now, on a rash of social media threats at schools.
Even in these first weeks of schools, Broward and Miami-Dade districts were responding to phone threats and social media scares that they simply cannot ignore. Local 10's Jeff Weinseer starts off our discussion.
The latest kid in court, a 14-year-old Don Sofer Aventura High School student who allegedly posted a picture of himself on Snapchat with a gun. The caption read, "Watch out at school tomorrow."
It hasn't stopped. We are continuously being bombarded.
Prosecutor Maria Schneider has been head of the juvenile division in Broward for 22 years.
It's the frequency of the problem.
Since school started, Nova, MacArthur, and Aventura High School students have been arrested for making threats. Dillard High School was evacuated after a threat. Schneider says there are new cases every week, many the media doesn't hear about.
We're seeing, honor students, straight A students. We're talking thousands and thousands of dollars in terms of time and resources.
Are most just joking?
It's hard to tell. We can't tell them apart, and we can't afford, because of the potential seriousness, to take any of them lightly.
In the juvenile division, the goal is not to throw someone in jail. It's about rehabilitation, very expensive long-term psychological evaluations that we pay for. So a kid that texts or puts out, "I want to shoot up the school," could technically be back in that school after going through these programs?
Yes.
We are tracking every student, and every student that has any type of threat, even if it's not one of the serious ones that you mentioned.
Schools are investing in threat assessment teams, money that's not going to educate our kids.
Last year, we quadrupled the number of threat assessments just by the nature of some of the requirements by the new law that was put in place.
Does the system work?
That's the million-dollar question. I have to believe that it does. Does it work for everyone? Unfortunately, we know that it doesn't.
The 14-year-old's attorney claims the gun in the post was a BB gun. Nonetheless, the judge is holding him in custody until a psych evaluation and a threat assessment can be done. For This Week in South Florida, I'm Jeff Weintz here.
Jeff, thanks very much. Well, Superintendent, what do you think accounts for this rash of threats from young men, mainly young white boys who are threatening to shoot up schools? What's going on?
I don't have a handle on what the cause is. I think there are lots of things out there that we certainly can look into. I think what we need to do is to make sure that as an entire community that we're on alert and that we work together to make sure we can address these things and they can be actually identified and stopped. So, for example, I continue to encourage every single person in our community to download our Safe for Watch app, which we've worked with law enforcement, where you see something, say something, and send something. Those are being looked at. It's actually sent to law enforcement and the district at the same time. There's also the Fortify Florida piece, but really notification is one. The second thing I will tell you is that as part of our safety infrastructure that we've invested heavily in this district, we've created 3 research analyst positions where they're spending their time on social media to identify issues that
So
emerge.
they're reading social media sites
right.
looking for
So
posts.
those positions, we're in the process of actually hiring them and placing them. They will be in place this year as another layer that's out there. That's just what we have to continue to do. It's an unfortunate situation, but what I will say this is, because of the advent of social media and the proliferation of this, we have opportunities to get signs and notices of this. The last thing I would say is this is a very, very serious situation. These are felony offenses, and children will be prosecuted for doing this. So what we've done is we actually have Judge Tudor and Judge Elijah Williams from the court system. They've actually we've created a message with them, a public service announcement, which I'm going to introduce this coming week at our school board meeting, and then we're going to show that regularly so that parents in the community have conversations with your kids. This is not a joking matter.
You bring up something like exactly what I was going to ask you about, is that this is, every parent has to be just so frightened that this seems to be a new normal, not just in South Florida, but across the country. And one of the real issues in juvenile justice is you take a juvenile, one of them said it was a joke. The boy from Aventura then posted it was a joke. Of course, no one's taking it as a joke.
No, it's not.
As a joke. But when you come down to prosecuting a juvenile for something like this, the difficulty is in the balance of a kid who doesn't want to be marked for life as a criminal if he really or she is not one, but having the type of consequences that prevent that juvenile from being a criminal. Speak, if you would, to the criminal justice, juvenile justice aspect of that balance. Much of what the Promise program that the district is doing also faces that real balance.
Yeah, so there's been, and I thank you for that. I would say, if you put it in context of First of all, these type of offenses would not be eligible for promise. Felony offenses, criminal offenses are not.
But are eligible for arrest.
They absolutely are eligible for arrest. And so that is a big fundamental question in our society, right? Do we want to incarcerate and punish, or do we want to create consequences and rehabilitate and help people learn and improve from their situation? I think we've, as a society, shifted, you know, in the 60s, 70s, you know, with the tough on crime stance we've taken nationally. And it's really been more about incarceration and punishment. But at some point, these individuals, you know, they get released from incarceration. They're in our society, and we haven't really done anything to rehabilitate them to integrate and become productive members of society. So it's a conversation that needs to be had at a national level of what we're actually going to do in this country relative to our criminal justice system.
Yeah, Mr. Superintendent, the Marjory Stoneman Douglas Safety Commission this week has said merge the Promise program, which you began 6 years ago, with, I think, every good intention. Maybe it sort of got out of hand, got too lenient, in the opinion of many,
Yes.
but to merge that with the juvenile diversion program run by the state attorney, because one program really doesn't know what the other one is doing. Is merging these two programs the way to go?
Well, first of all, we need to step back and understand the context in which the Promise program emerged. This isn't something that came from the school district, right? This arose from requests by law enforcement agencies, the public defender, state attorney, Children's Service Council, teachers unions, lots of folks in the community that identified a problem. That problem was that students, young people, whether they were in school or out of school, who committed these minor misdemeanor offenses which didn't warrant them going into the
They
juvenile
wound
justice.
up in the criminal justice system.
No, they didn't, because these offenses did not warrant that. So the state attorney, they would send them back to like the district, and we would apply discipline to them, which was basically suspensions. We've suspended over 50,000 kids a year. And so what would happen is, once you're suspended, you go to what's called alternative to external suspensions, such as one of our facilities, Lanier James, or you sit at home or you're on the streets. So law enforcement were picking these kids up on the streets, getting into trouble, and said, why are you out here? Say, oh, we're suspended from school. So they get their 3 or 5 day suspensions on the street, they're getting into more trouble, and then they're back in school. Promise came about to, one, make sure they had consequences. Number two, that they were in some place where they were actually learning from what they were doing. They were being supervised. They were getting wraparound services. They were getting interventions, and they were getting involved in restorative justice. So if we take the Promise program away, this community is going to have an answer to, what are we going to do with these kids? Are we going to put them out on the street again, or are we going to actually do something that's going to provide interventions
But
and help?
the knock on the Promise program was that kids who commit fairly serious offenses were getting not only second, but third and fourth and fifth chances, and were endangering their behavior, endangered their school environment.
That's not accurate, because life-threatening, felony, criminal-related offenses are not eligible for Promise. That is a piece of misinformation that's
well,
out
then
there.
set the record straight.
So the record straight is that those type of incidents are not eligible for Promise. Only about 3% of 50,000 suspensions that we have annually are eligible for the Promise program, and that is consistent with state statute that identifies what these things are. Now, there was amendments that were made to the law that impacted programs like Promise, which, by the way, versions of it exist around the state. We've made those modifications. One of the things that you mentioned is these repeat constant bites at the apple. So we've limited, you have 3 potential times that you can interact with Promise over your entire academic career in Broward County. And what I would say to you, even going prior to that, this narrative that there were all these kids that get, I looked at the data myself, and one of the pieces of data I looked at, I said, okay, students that had 3 or more offenses in one year, that went and had multiple offenses, 3 or more offenses in subsequent years, and I looked at that over the first 4 or 5 years of the program, I found 11. And half of those students weren't even at any of our traditional schools. So nevertheless, so I suggested, look, let's go change it, because it's not really having an impact on the students that we're trying to serve and assist through this program.
But isn't the problem what you see is not a total picture? You see what's in school. Whereas this child could be committing some sort of offenses that has nothing to do with school, and you would never know, and conversely, the state attorney's office wouldn't know what you know when they bring this child in for something. And so wouldn't that be a reason, and a good reason, to merge the programs so everyone's on the same page?
Look, so the sharing of information and so if there's a way to improve information, and that's an actual valid concern that's out there, I think it's something that we could look at. But at the end of the day, I go back to why did we create this? And we need to somehow be able to provide this kind of service to these students. And I would say that law enforcement has access to student information whenever they need to, right? So the SROs who are on campus, when some incident occurs out in the community, they can contact us. We share the information. I don't know of cases where law enforcement has asked us for information about a particular student and we have not shared that. So that is available. One of the topics that comes up is, unfettered real-time access to all student data, and we're just not at a position
There's
where
confidentiality involved there as well.
But I don't worry about confidentiality when life safety issues are on top. But why open up a whole entire database for no reason? When there's an actual incident involving a juvenile, that information becomes available to law enforcement as needed. But again, we will always explore opportunities to better serve our kids, to make sure that we have a system that holds them accountable and that we can address the safety needs in our community. So that's an ongoing conversation as we continue to look to improve that program and work with our community partners.
Robert Runcie, we thank you very much. There's more to talk about. We didn't even talk about all the academic programs. You can come back and
We'll look forward to
talk
that
about
ongoing
Yeah,
conversation.
or even all the significant investments we put in safety. I mean, just a quick thing. When
Hear that music?
Yes.
We gotta go.
You can't. We hear the